Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-7043, Communications Workers of America, AFL-CIO Appellant versus AT&T Inc. Mr. Anderson for the appellant, Mr. Baskin for the appellee.
Good morning, counsel.
Good
Mr.
morning.
Anderson, please proceed when you're ready.
Good morning, Your Honor. Michael Anderson for the Appellant, Communication Workers of America. AT&T and the communication workers have a contract that governs the definition of bargaining units. And all parties agree that under this agreement, that at those workplaces that existed as of the commencement of this contract would be subject to binding arbitration about the scope of bargaining units through this arbitrator. The question that comes up here is that during the term of the contract, AT&T acquired Time Warner as a component of its broader corporate family. And the union contends that under this agreement, the union is entitled to the same bargaining unit determination through the arbitrator as applied to those workplaces that existed at the outset. Now, there is a paragraph of this agreement that speaks to this. It's about the recognition of new entities and new work, which expressly covers what happens when AT&T acquires new companies. Now, as the district court in AT&T read this provision, it means that there is absolutely no binding right to arbitration. That in effect, everything in the agreement, except for a hortatory right to use best efforts to meet and confer, that nothing binding in the contract applies as to those acquired operations. And if that were true, we would have expected the parties to draft the agreement to say, this agreement shall not apply. But that's not what the parties wrote. The paragraph 6 of the agreement says that if the company acquires new companies, then the parties agree that this agreement shall apply to that acquired company. And the fundamental point the union makes here is that when the parties reference the agreement shall apply, they expect that the arbitration provision that is embedded within that agreement shall also apply.
Can I ask you a question, Mr. Anderson?
Yes.
So under paragraph 9 of the agreement, paragraph 9 says, with the exception of matters referenced in paragraph 3C above, the meaning or application of this argument shall not be subject to arbitration. So the agreement specifically says that some things are subject to arbitration and some things are not.
Absolutely.
And as I understand the question the Supreme Court is currently considering in the Henry Schein 2 case, it dovetails with that kind of provision because it has to do with the circumstance in which the agreement provides for arbitration over some matters and carve-outs over others. And I guess my question is, do you agree that the question that we have before us is bound up in the question that the Supreme Court has before it now in the Henry Schein case?
Yes, I do. And if the Supreme Court reverses the Fifth Circuit in Henry Schein, it would not be necessary nor appropriate for this court to speak to the merits of the argument that's presented in Roman numeral 1 of my brief. You would simply refer that dispute to the arbitrator.
Right, and the very issue before the Supreme Court is whether the issue gets referred to the arbitrator.
Absolutely.
It's the arbitrability question at the outset as opposed to the proper construction of the agreement.
This court should not decide this case until you hear from the Supreme Court in Henry Schein.
Mr. Anderson, isn't, the general rule about determining who determines arbitrability is a question of contract interpretation. So, the contract here is obviously different from the contract in Henry Schein, right? It has a general rule of no arbitration and then a specific area in which arbitration is to go forward. So I'm not sure that the contracts are necessarily analogous enough. And in any event, the court has to interpret the contract in order to determine the question of arbitrability.
That's true, but in agreeing to proceed under AAA rules, the parties agreed that disputes over the arbitrator's authority, that is, which disputes fall across the line of what is arbitrable and what is not, is delegated to the arbitrator. And the court can't frame a consistent rule of law based on how big the carve-out is.
Well, I guess I wouldn't say this is a carve-out. This is a different kind of case, because in most of those other cases, there's an arbitration provision that says something like all disputes to be governed by arbitration under AAA rules, maybe except for a few. But here, Section 3C is very specific about the narrow things that will be arbitrated. It says the issue of the description of such unit shall be submitted to arbitration. And then it goes on to say the arbitrator shall be confined solely to the determination of the appropriate unit for bargaining. And I think if you read that in connection with Section 9, which says, with the exception of matters referenced in paragraph 3C, the meaning or application of this agreement shall not be subject to arbitration. Reading all of that together doesn't suggest a clear and unmistakable intent to leave questions of arbitrability to the arbitrator.
That's correct as a general matter, except here, the union is coming to the arbitrator, or wants to come to the arbitrator, to say, we think that this is an appropriate unit that needs to be determined by you. And to the extent that there's a dispute over whether Time Warner units fall within the scope of the arbitrator's authority, that's exactly the kind of thing that's delegated under the AAA rules.
Well, that goes to whether the dispute is arbitrable. It doesn't go to the dispute about whether a court or the arbitrator should decide arbitrability.
Yes, but the point is there's a dividing line here between what's arbitrable and what's not. And the parties disagree about whether the Time Warner units fall on what side of that line. And if the Supreme Court decides in Henry Schein that the limitation on the arbitration clause doesn't change the arbitrator's authority to decide arbitrability under AAA rules, then there really isn't a meaningful distinction between this case and Henry Schein. Otherwise, the court would have to say, well, if there's an exception to a general rule of arbitrability, then the arbitrator gets to decide. But if a narrow subject matter is defined, then the court has the power to decide. That ends up making distinctions between an exception to the rule and a rule to which there are exceptions. And that simply doesn't result in a consistent rule of law.
I guess the overall question, though, still is, under the Supreme Court's cases in First Options and its AT&T case, a question of contract interpretation. It's not a question about a general rule and a carve-out and things like that. And every contract is arguably different, and you have to take a look at the way a specific contract is written. Right? I'm not sure that, you can establish specific rules for the interpretation of every single contract, because contracts are very diverse.
That's true, but to the extent the parties knew what they were doing when they said that the arbitrator would be governed by AAA rules, and they knew that those AAA rules empowered the arbitrator to decide disputes about arbitrability, it doesn't matter whether the arbitrated matter is a small percentage or a large percentage of the total amount of disputes that might be subject. There's still a delegation to the arbitrator to decide that question. And if I may, I'd like to reserve my remaining time for rebuttal unless the court has further questions.
Sure. Thank you, Mr. Anderson. We'll hear from Mr. Baskin now.
Good morning. Maury Baskin for AT&T. We begin by saying that the district court had it exactly right, because the parties did not agree to arbitrate the issues arising under paragraph 6, which I must say has been somewhat mischaracterized by opposing counsel, because paragraph 6 is not merely a meet and confer provision. It establishes detailed binding obligations on the company that it otherwise would not have, which are legally enforceable, about how to deal with new lines and acquisitions of companies that are required. Moreover, the assumption was made that the agreement applies automatically to these new acquisitions, but in fact, it only applies to new acquisitions where there is no bargaining agreement in place. And in fact, the Warner Media acquisition is heavily unionized. This is a This is a neutrality agreement to organize. Well, if it's already organized, it does not apply, and that is what paragraph 6 means. And we have a general rule of arbitration not applying. This is what has already been discussed, and I should turn to the Shine case, because as for the reasons that we said and that have frankly been identified by Judge Rao, Shine is the flip side. It is not the same, and one need only look at the very narrow question on which cert was granted in the Shine case, which was discussed extensively in the oral argument there, and it was described by a commentator as the most prominent theme of the argument was how narrow the question was, because they assumed in the question that it was an otherwise clear and unmistakable delegation of the question of arbitrability as to the dispute to the arbitrator. And I think Justice Alito commented, well, once we've said that's the question, we pretty much answered it. And it's such a narrow question. It's an artificial question. It is not the question in this case. We do not have a clear and unmistakable delegation to the arbitrator about an issue which the parties have designated as not covered by arbitration. And it's ironic, the union attorney—
Isn't that just a question about how clear and unmistakable it is? Because if one were to think that the incorporation of the AAA means that the question of arbitrability goes to the arbitrator, at least in some situations covered by the agreement, would you at least allow for that, or do you dispute that?
It allows it for what it's specifically limited to, Section 3.
Right. So it allows for something. Yeah, that I think then we're agreeing at least on the premise, which is it at least contemplates arbitrability of some things. And I'm not necessarily taking issue with your proposition that, the things that it allows for arbitrability of are narrow. That may or may not be true, but I guess all I'm saying is by incorporating the AAA rules as expressly as this does, without any kind of caveating, then it's at least talking about the arbitrator making arbitrability determinations in some corpus of situations. And then if one of the parties says, well, this is one of those situations, and the other party says, well, no, it's not, then it seems like the difference we're talking about between this case and Henry Schein is kind of a ratio question of how big or small is the corpus of things as to which arbitrability goes to the arbitrator. And it's not immediately apparent to me why it at least wouldn't be the case that what the Supreme Court says in Henry Schein could bear on the resolution of a case like this, and whether there's an administrable line to be drawn between cases where there's a narrower set of issues that are arguable, that are subject to arbitrability, and the arbitrator determining arbitrability, and cases and contracts in which there's a broader set of situations in which the arbitrability question goes to an arbitrator. We're just talking about a ratio at that point. Or am I misunderstanding, please? Sorry.
Let me just provide two answers to that. One is that the Supreme Court, unless they're going to overrule AT&T Technologies, in that case, the Supreme Court said it does make a difference as to how broad or narrow the delegation is. And also the Supreme Court said that where there's a positive assurance that the arbitration clause does not discover the dispute in question, that too is a factor that is supposed to be considered. So the Supreme Court has always said that there are lines, degrees, and this is at the extreme opposite end from what is being talked about in the Henry Schein case. And I want to add one other reason that distinguishes this. It's a matter of faulty pleading, that the union has identified not a single bargaining unit whose definition is improper and that needs to be arbitrated. They just make this broad conclusory statement in violation of Twombly and Iqbal, the standard test, which the district court applied, and they don't identify a single unit that previously exists, which is all that the arbitrator would be allowed to consider. They don't identify a single unit which is organizationally different. Not only that, they don't identify under paragraph 6 a single unit of Warner Media that is not already organized. And the irony of this is they have said that our reading of paragraph 6 makes it meaningless. Well, their reading of paragraph 3 makes the entire rest of the agreement meaningless. It makes paragraph 9 meaningless. The parties deliberately said they do not consent to arbitration on anything except that one.
I mean, can I say, it sounds to me like your argument at the end of the day is that the union's argument that this is arbitrable is totally groundless. And that's what Henry Schein said still goes to the arbitrator.
Well, so, we haven't said that. What we have said is that the dispute is that it's two things, that the dispute at issue is totally under paragraph 6, which has no arbitration provision. It has no delegation. There is no clear and unmistakable delegation. And one can say with positive assurance that it is not subject to arbitration and not subject to delegation to the arbitrator, combined with the failure of the union to plead with specificity a plausible unit that needs to be, that is in dispute. Without that, they don't get into the questions that are discussed where there is a clear and unmistakable delegation over a particular dispute. There is no particular dispute identified anywhere in the union complaint.
And Mr. Baskin, this is a hypothetical. If I don't agree with you about paragraph 6, if I think that paragraph 3C1 is applicable here, just assume that I think that's the case. The parties here are disagreeing about the definition of a bargaining unit, right? In other words, whether it includes Time Warner jobs. That's what the dispute is.
No.
So if the court decides that question, then what's left for the arbitrator? I mean, isn't that what's left?
Well, that's what AT&T Technology says. It does not. There's no requirement that anything be left for the arbitrator. The fundamental question. But
paragraph 3C1 says disputes arising are subject to arbitration under the AAA rules. And under your view, that wouldn't occur. There would be no arbitration because it would be resolved by the district court.
If there is no dispute over a definition of a previously existing unit, then that is the inevitable conclusion. So I guess it's the premise of the hypothetical cannot be accepted because.
Right, but under my hypothetical, you're eviscerating the arbitration part of it. There'd be no arbitration. That's why I said it was a hypothetical. If I'm right, if paragraph 3C1 applies, then would you concede then that if we think interpreting this contract that is subject to paragraph 3C1, would you then concede that the district court was wrong and that the question of whether it includes Time Warner jobs is subject to arbitration? Right.
If paragraph 3C, accepting the premise of your hypothetical, then we would.
You would agree with that. So it all
is a stronger case.
Gotcha. But to the whole case, that's good. So the case turns really on the broader question that you were raising about the other aspects of the contract, right? And whether it's clear and indisputable. Okay, got it. Thank you.
Yes, and it is impossible to make a finding that 3C1 applies. So
it's impossible what?
It is impossible to make a finding under the plain reading of this agreement that 3C1 has any application. That's what the district court found. He said there's no indication whatsoever that the parties delegated to the arbitrator to decide the actual dispute, which is what to do with new entities and acquisitions. I see my time has run out, but thank you very much.
Can I just follow up? I'm not following one thing, which is to say, if there's no dispute whatsoever, what's the difference between that? Where's the line between that and saying it's wholly groundless to say that the dispute is arbitrable?
Well, I'm not frankly sure what the Fifth Circuit meant by wholly groundless, and but that. Well,
what did they mean other than there's no mistake? I mean, it sounds similar to me, but I'm.
Well, there are different formulations, and that's why I prefer to use the formulation of the Supreme Court in AT&T Technologies, which it has to be clear and unmistakable on the disputing question. And even where there is a presumption, if there is positive assurance, that's the Supreme Court's phrasing. I think that's a good one. And there certainly is positive assurance that delegation has no application to this case and has not been pleaded to establish facts to justify that.
Okay.
Thank you.
Thank you, Mr. Baskin. Mr. Anderson, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. Just to touch on 2 points. To the extent that counsel is arguing that the union's submission to the arbitrator is not right and insufficiently detailed, he's making a 12b6 type of argument, which is an argument for the arbitrator. It's for the arbitrator to decide whether the union's pleading meets sufficient requirements in order for him to decide a question. There is something that goes to the possibility that the Supreme Court may say that these issues are for the court that I do want to touch on. It is not correct to say that the parties did not in any way delegate matters under paragraph 6 to arbitration. Paragraph 6D says, except as specified in paragraph 9, the union shall retain any legal rights it may have to challenge any management decision, which tells you that the parties understood paragraph 9 somewhere to contain an obligation, a limitation on the union's ability to proceed outside the contract. And when you look at paragraph 9, aside from pledging best efforts to meet and confer, the only binding obligation to be found in paragraph 9 is in the initial proviso, except as to disputes referenced in paragraph 3C of this agreement. So that to the extent that the court may end up having to decide this question, you should see paragraph 9 as being understood by the parties in paragraph 6D as providing a binding obligation that limits the union's rights under background law. And the only possible part of paragraph 9 that supports that is the proviso that preserves paragraph 3C. So based on that, it's simply not true to say that the parties did not contemplate that paragraph 3C arbitration would apply to new entities under paragraph 6. And I see my time is up, but I'm anxious to answer any questions.
Could you just repeat once more in the clearest way you can your answer to Mr. Baskin's argument that it's impossible to read this agreement as applying paragraph 3C1 to this case?
Yes, the party said
just as clearly as you can. What's your answer to that?
The party said this agreement shall apply, which presumptively means that the arbitration provision within that agreement applies. Paragraph 6D identifies paragraph 9 as a limitation on the union's background legal rights. And paragraph 9, in turn, provides only for paragraph 3C arbitration as the only meaningful form of limitation on the party's background rights and remedies. So to that extent, the parties agreed that paragraph 3C arbitration would apply.
Thank you.
Okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 19-1212, In re Nashwan al-Tamir, petitioner. Ms. Skelton for the petitioner, Ms. Taryn for the respondent.
Good morning, counsel. Ms. Skelton, please proceed when you're ready.
Good morning. May it please the court. We are here this morning because the military commissions have refused to take this court's decision in al-Nashiri seriously. There's the issue of the CMCR trying to circumvent this court's clear directions regarding remedy with the acknowledged error in Judge Waits's application to be an immigration judge. But there's also the fact that the CMCR and the military commissions ignored the apparent conflicts that surrounded Matthew Blackwood, a senior member of the trial judiciary who was explicitly responsible for shaping judicial decisions. He presided over ex parte SIPA-like hearings with the prosecution without the military judge present. He used a judicial ruling as a writing sample secretly to the National Security Division, which represents the government here. And he traded on his position as a senior member in the trial judiciary to get a job with a component of the Department of Justice that is also part of a military commission's prosecution team. No member of the public would consider this to be a fair and impartial judiciary. To be clear, Matthew Blackwood was not a law clerk in the sense of a federal judicial law clerk. As I mentioned, he presided over these ex parte SIPA-like hearings under Military Commission Rule of Evidence 505. This is something that a magistrate or a special master would do. In multiple instances, the military judges did not even have access to the classified computer systems, so Matthew Blackwood was the only one who did. He was a GS-15 subject matter expert, which was the same rank as Waits and Rubin, and he in fact outranked Judge Libretto. The judges were part-time on the military commissions, maintaining an active court-martial docket, whereas Matthew Blackwood was the only senior member of the trial judiciary that was full-time assigned to the Hadi Commission. And he was, of course, long-term. He was there through multiple years as 3 judges came and went. He had a dynamic, innovative legal work that would play a major role in shaping case decisions. That's a quote from his job description at page 799 of the Joint Appendix. So the ethics rules that are limited to law clerks simply don't address what his role is. He also testified how important—
Ms. Kelton, if you could then say, what are the ethics rules that should apply to Mr. Blackwood? You're suggesting he's more like a magistrate or a special master. I mean, do you think the judicial ethics apply to Mr. Blackwood?
Absolutely, Your Honor. First of all, the judicial ethics apply to every member of the modern judicial family. The fact that there are some carve-outs for other job searches is, it just simply doesn't apply to Mr. Blackwood. The restrictions on how a magistrate would search for a job as their term comes to an end is far more applicable. And truly what needed to happen is disclosure of his attempts to find a job with a party to the prosecution. And at that point, steps could be taken. Perhaps Mr. al-Tamir would have waived the apparent conflict, but the judges would have been able to then secure the integrity of the decisions coming out of their chambers. We are not suggesting that Judges Rubin or Libretto intentionally shaped rulings to help Matthew Blackwood. The real issue is, how did he shape rulings in ways that the judges did not even know?
Ms. Hill, just to pursue the same question, you're seeking mandamus, which means your relief, you must be clearly entitled, clearly and indisputably entitled to it. I've been unable to find any case in your briefs or anywhere else which says that a law clerk that simply applied for a job, as opposed to one who got an offer, has a disqualifying conflict. Am I right about that?
Your Honor, I actually disagree with that, but again, he's not really a law clerk. So those cases are the closest analog that a lot of the federal case law would have. But the fact that those cases skew a little bit differently, it should not concern the court, because in fact, the cases also say that there is a spectrum of behavior on a law clerk's job application. And
you see, that's sort of just my point. That, combined with the fact that the job he ultimately got was with the U.S. Attorney's Office, right?
It was. Yeah,
which is different from the situation in al-Nashiri. All of those combined, it's just, how do you make the case that you're clearly and indisputably entitled to this right, this relief? It has to be. Do you see my point? This is a mandamus action.
Absolutely, Your Honor.
And so there can't be any doubt about the petitioner's entitlement to relief on this issue.
And
for us to be able to grant mandamus.
And there is no doubt. First of all,
I guess that's where I'm not yet convinced. I haven't seen that in the briefs.
So the particular U.S. Attorney's Office where he got a job, during his interview, he interviewed with a member of the prosecution team prosecuting Mr. al-Nashiri. During that interview, they discussed Mr. Blackwood's role as a senior member of the trial judiciary. And during his job application to the National Security Division, he secretly used a writing sample that was that was one of Judge Rubin's opinions, and that writing sample issued a ruling that excluded Mr. al-Tamir from classified sessions of the Military Commission. So he was trading on his position. There's a spectrum of law clerk behavior, if we assume that law clerks are the correct analogy, that would raise issues. Whatever that line might be, Matthew Blackwood was so far on the other side of it, especially in light of the fact that he was presiding over these ex parte meetings with the prosecution. The Ninth Circuit's case in the First Arizona Bank is probably this court's closest case to look to. The thing is that most of the time, everyone does this right. And so there's no need to go back and look for exactly where these lines are. And that's why the rules are in place. We need objective rules so that there's no question. Here, there's whatever the line was, Mr. Blackwood had crossed it. And that is where our clear and indisputable right to relief comes from. This court.
Let me ask you a different, no, you go ahead.
Oh, okay. If we assume that Blackwood's disqualification, did not also disqualify, judges Rubin and Libretto. So the only possible disqualification is based on Judge Waits. I guess why isn't it an adequate remedy to allow reconsideration of Judge Waits's decisions as the CMCR is, undertaking or has ordered to be undertaken? Why isn't that an adequate remedy here, at least to see how that process goes?
For multiple reasons, Judge Rao. First of all, the government asked for reconsideration as a remedy in al-Nashiri, and this court rejected it. Specifically, this court commented that it had to vacate the CMCR's rulings as well because it was unsure how Judge Spaff's rulings would have impacted it. Because ordinary appellate review after the fact cannot scrub the taint.
Let me just interrupt, because I think Judge Rao's point is the alternative here isn't appellate review. The alternative here is de novo review of all of Judge Waits' orders. So it's a different problem.
So that is still an inadequate remedy. Judge Waits.
But why? That's Judge Rao's question. Why?
Sure. The reason is because Judge Waits's rulings that came at the very beginning of the case have shaped the entire litigation. For example. So
your concern is about the rulings post Judge Waits, right?
Certainly we are. So Judge Waits's rulings themselves.
But let's take this step at a time. What about for just his rulings? Wouldn't this be a perfectly adequate remedy to have a different judge de novo review every order you identify?
Your Honor, it would not be adequate simply because we have seen that the CMCR and the military commissions have been unable to follow this court's clear direction. But truly, all of
that's a different problem. I agree with that. That's a problem. But just focus on Judge Rao's precise question, which is why wouldn't de novo review of every order you identify, setting aside the question of post Waits orders, just his, why wouldn't that be adequate? Well, in fact, why is that any different than dissolving the commission? Isn't that the same thing?
As a practical matter, if you void every ruling that Judge Waits made, it probably
No, that's not the question. No, the question is petitioner here gets to identify every order he wants reconsidered de novo. What's the matter with that? And isn't that even better? Because you get to keep the ones you like.
Your Honor, we certainly were offered that and rejected it because we saw it as an invitation to error. We don't know how even.
But you haven't told us why.
His later rulings were also informed by his earlier ones. So
no, but all of his all of his rulings will be reviewed de novo. Judge Waits' rulings. I don't have any doubt you're right that his later rulings were influenced by his early rulings, but the offer here is to de novo all of them.
It is impossible to extricate his rulings from the rest of the commission. We have
no. Can I just not the rest of the commission. Let's assume a world in which he's the only one who's issued any rulings.
Right.
And if we assume that world, so we're not talking about the spillover consequences for any other judge who might come along later. Let's just assume a world in which he's the only judge that's ever sat. In that universe, if the remedy is you get to pick any ruling you want that gets de novo reconsideration by somebody else now, why isn't that seems like something that's equivalent to al-Nashiri, except to the extent it's not, it's to your advantage because you get to preserve certain of his rulings. Otherwise, how is it any worse than what happened in al-Nashiri?
Just Srinivasan, what these hypotheticals suggest is essentially vacating the entire proceedings. And it's a little hard to go to assume that the 4 years that followed Judge Waits didn't happen. So
I think all we're trying to do is isolate
right.
the source of the possible dispute here. And I just, as a predicate to that, I think it's helpful for all three of us if we just at least deal with the premise that if we're not talking about spillover consequences for rulings by the other judges, and we're only talking about what Judge Waits did, then that the remedy that's in effect now, which is that you get de novo reconsideration of any of those rulings that you choose, that's no worse than what happened in al-Nashiri.
If we found out about this error on the same day that Captain Waits retired and were able to get to this court at that very moment, then the remedy the CMCR proposed could be adequate. It does overlook all of the oral rulings, and of course those rulings are also subject to vacator. Those rulings are also void. There are of course some very
I think they should. I don't. Is there a dispute about that? I would assume that a ruling that it encompasses oral rulings too. Is it not the case right now that you can get de novo reconsideration of any oral ruling by Judge Waits?
That is certainly not how it has appeared from how the CMCR phrased things or how Judge Libretto did, where we were supposed to provide a list of AE numbers that provided orders that we wanted reconsidered. But that particular remedy of reconsidering oral rulings, that's a very difficult bell to unring. There are rulings on voluntariness of our clients waiving an appearance to participate in a particular hearing. Once that has been ruled on orally, it's our position that everything that follows, of course, has to be void, because assuming that our client had not voluntarily waived an appearance, there's an oral ruling, and everything that follows simply has no further legitimacy. Assuming that the remedy that this court is trying to fashion is supposed to sort of reinvigorate the integrity of the judicial system, parsing the potential, trying to draw the line that fine simply fails to do the sufficient reinvigoration necessary. And of course, it entirely overlooks how interconnected all of the rulings are. For example, Judge Waits, within a month of applying for his immigration judgeship, he entered a protective order that limited what information Mr. al-Tamir, unclassified information Mr. al-Tamir could share with pro bono experts. Within a couple of months of that, he issued a ruling that limited Mr. al-Tamir's access to witnesses. These, of course, shaped everything that happened after that point. All of the 505 substitutions, classified evidence, shaped discovery litigation, including the deposition that just occurred. I see my time is up.
Can I ask you one follow-up question, before we hear from Ms. Tarrant? If just assume for purposes of the question that I think that the remedy as to Judge Waits is functionally the same as the remedy as was at issue in al-Nashiri, except that you get to identify certain orders that you actually don't want to have reconsidered. And then the question becomes, how would one deal with potential spillover consequences concerning the rulings by the judges who came along later? And is there a standard or some approach that you would suggest on identifying that corpus of orders that came along later that are sufficiently bound up in orders that Judge Waits issued?
Your Honor, I believe that your question is an impossible task, and it also imposes an impossible burden on Mr. al-Tamir. It is essentially asking to impose an actual bias standard instead of an apparent bias standard. One of the things that the defense cannot do and should not be able to do is to point to precisely how the apparent bias impacted decisions. But we do know that Judge Waits's decisions impacted later ones. Every decision that he made on a substitution for classified evidence impacted investigations, impacted other motions, impacted other discovery litigation down the road. So there could be ways that a ruling, even in favor of Mr. al-Tamir early in the case, but not a complete ruling in his favor, limited what our investigation was, limited what the defense could do in further discovery litigation. To parse it that finely would to read al-Nashiri down to a nub, it would be an impossible task. And again, that is exactly why an objective rule with a brighter line is necessary. It is.
Well, suppose just to pursue this a little bit, when you answered Judge Srinivasan's question, you said that that's to impose on petitioner here an obligation to show actual bias. But suppose, in answer to his question to you, suppose the standard was that all petitioner had to do was to show, I'm talking about the post-Waits orders now. And remember, this is mandamus. So the question is there an adequate alternative remedy? Suppose all he has to do is show, quote, like maybe a reasonable possibility that a later order was affected by an earlier Waits order. Just a reasonable possibility. Not that it was infected, but just a reasonable possibility. Why, if the government, if the commission were willing to do that, how could we say that that is not an adequate remedy, at least at the moment?
The reason
it might turn out not to be, but that could be reviewable. But at this point, why wouldn't that be enough? When you compare it to the alternative of dissolving the commission, which we said in al-Nashiri was a draconian solution that we were trying to avoid.
Sure. Judge Tatel, I have two different responses to your question. First is that the reviewer looking at those prior decisions has no way to actually know how the apparent bias impacted it. So it essentially would be turning a legal question into...
Excuse me, I'm sorry to interrupt you. The question isn't whether the bias affected it. The question is whether the order that on de novo review has been reversed affected it. So for example, suppose in the de novo reconsideration, the judge takes a look at a Waits order that denied discovery and says, and he says, he reverses that. I'm going to grant discovery on that. That discovery motion should have been granted by Waits. Now, it seems to me that it's pretty obvious that that decision is going to have affected later decisions, because it means that petitioner would not have had the evidence from that discovery order in support of his later motions. So it's not that the later motion is affected by the bias, it's just that it's affected by the fact that the motion was denied. Do you see my point?
I do, Your Honor.
Yeah.
I think candidly that Your Honor's question proves the point that it's an impossible task.
I see.
And It's a difference. It is why a clearer rule is necessary. And also it is why we need to see that what has happened in the military commissions is a constant refusal to read this court's clear directions. They heard vacate, or they read vacate, and they heard reconsider.
Okay, let me ask you this. You said my answer showed that it was impossible. So I have an impossible question for you. Do you have any sense, and I realize you may not know the answer to this, do you have any sense at all as to what effect Waite's orders might have had on later orders? Is there any way to quantify that at this point so that we understand what the risk is of choosing one option over another?
Your Honor, do you mean to quantify in the sense of how many orders they impacted?
Yeah, like how much of the post-Waite's decisions do you think are affected by what Waite's did?
I can't give you a specific
There's no
number.
way to know, right? Do you know how many post-Waite's orders there are? Are there hundreds?
There are hundreds. I mean, a certain number of those are motions to continue, schedule.
How many, are there hundreds of substantive orders?
There probably are.
Yeah.
However, to set the court's mind at ease about the scope of litigation. Now, it's a big request. This is the notion of voiding the proceedings from the time of Captain Waite's application. I fully understand that is a big request, but that is a necessary request. And the fact that there has been a substantial amount of litigation, it still hasn't gotten to judgment. We are still in a better situation than this court having to vacate the verdict and redo everything, including a trial. In comparison to, for example, the 9/11 Commission that has about 33 or 36,000 pages of pretrial record, the Hadi Commission has closer to about 3,300. There's more than that because there's some closed hearings that I don't have transcript page numbers for. Huge number of the actual days of hearings were short, an hour or less. There's also been delays in this court caused by Mr. al-Tamir's health. There's been delays because the government held him without charge for years. There are certain inefficiencies to what we are asking for, but they are far less than the inefficiency of having to redo this after verdict.
And I take it, so your position is, even though as you say it, the vacated remedy that you're asking for is a fairly extreme one, that there's nothing short of that is workable or acceptable.
Nothing short is workable. And
in between what is on the books now, which is de novo reconsideration of everything Judge Waits did, and complete eradication of everything that's happened to date. There's nothing in the immediate. And even if, for example, if you take the proposition that Judge Tatel asked you to engage with, which is a sort of reasonable possibility standard, even if it was flipped so that it was incumbent upon the government to show why there's no reasonable possibility, as opposed to incumbent upon you to show why there is a reasonable possibility, that regime still, to you, is something that's unworkable.
It is unworkable, and the reason is because of the timing of things. Now, in Nashiri, there was sort of an intermediate remedy because there were 4 years of untainted litigation that preceded Judge Spath's job application. So there was a clear delineation of untainted proceedings. Here, that simply doesn't exist. It was only the arraignment that happened and nothing else. So in order to basically have an equivalent remedy of everything vacated post taint, it's actually the same remedy that we are asking for. And it's the reason why in Lilleberg, that is the default remedy, that it simply is an impossible task to put Humpty Dumpty back together again.
Okay. Thank you, Ms. Skelton. Well, unless my colleagues have further questions from you, we'll hear from Ms. Taryn now.
May it please the court. In response to your question, Judge Tatel, there are 149 substantive decisions of Judge Rubin and Judge Libretto. And of those, Petitioner is able to point to only one that was affected by a decision of Judge Waits. And that was the decision of Judge Waits denying the defense motion for an order that would prohibit female guards from touching him. And when Judge Rubin was presiding over in-court proceedings, he had ordered the petitioner to appear in person, and the petitioner violated that order, refusing to come to court by renewing his objection to being touched by female guards. And Judge Rubin explained that he was going to overrule that objection and not reconsider the decision of Judge Waits on the ground that petitioner did not have a legal right to dictate the gender of the guard force. But the CMCR explained that to the extent petitioner is able to point to any order, including that order, that demonstrates that the decision of Judge Rubin or Judge Libretto incorporated or otherwise relied upon a decision of Judge Waits, then the new military judge, Judge Zimmerman, must consider those decisions de novo as well. And so we think the CMCR...
What does that exactly mean? Could you just take that a little deeper?
Sure.
Suppose, take my hypothetical that I asked Ms. Skelton about. Suppose they identify a Waits order denying a certain kind of discovery. Because there are a lot of discovery orders here, right?
Yes.
Yeah. Okay. So what would petitioner have to do in order to get de novo review of post-Waits orders?
Just point to the decision of Judge Rubin or Judge Libretto that either incorporated or relied upon that decision. And that could include even decisions that address ex parte motions.
Well, suppose it didn't rely on it, but suppose they say, well, look, Judge Rubin ruled a certain way against us, but that was because Waits had denied us discovery. We needed to win that, to prevail on that order.
Then we think the CMCR's remedy would require the new military judge to consider anew any decisions that were affected by that discovery order. Okay,
this is very helpful. So see if I can articulate it, what petitioner would have to show. Petitioner would simply have to say, take my hypothetical. Petitioner would would list the Rubin orders that he believes are affected by the denial of a discovery order by Waits. And under the offer the commission has made here, those orders that he identifies would be de novo reviewed.
Yes,
de novo reconsidered, right?
Yes, Your Honor.
Wait, just based on his identifying it?
Yeah.
Or would there have to be an assessment of whether, because as I understand what Judge Tatel asked you, and sorry to mean to interrupt, but as I understand what Judge Tatel asked you, it's that the other side identifies an order by Judge Rubin or Judge Libretto as having been affected by an order issued by Judge Waits. And you're saying once that identification is made, then the subsequent order is reviewed, subject to de novo reconsideration?
Yeah.
The CMCR indicated that the new military judge would consider. I think that under the CMCR's order, there would be an assessment by the military judge about whether...
An assessment of what? Do you have the actual language there? Is there any actual language we have about the post-Waits orders?
Well, the CMCR explained that with respect to this example about a female guards motion, that claim that petitioner raises that this decision of Judge Rubin was affected by Judge Waits's decision should be presented to the military judge. And then the military judge provides petitioner an adequate remedy, which we believe would include mandatory de novo reconsideration of that decision by the new military judge.
So does that mean the standard for the petitioner is just that they have to show it was affected by Judge Waits's ruling? Is that the standard?
Yes, Your Honor.
But
does that mean they have to show it was affected or just say it was affected? They reasonably believe it was affected. It's a big difference.
We think that they would just have to show that. Well, it would just have to.
Wait, you didn't answer my question.
Your Honor, we think that they would just have to identify that order.
Okay. That's what I was looking for. Okay. So, fine. That's very helpful. Okay. And then if they identify that order, the new judge would reconsider it de novo. Correct?
Yes, Your Honor. Yes, Your Honor.
Okay.
And even if you don't, just to push it a little bit further, they identify an order as having been affected by a prior order issued by Judge Waits. That's it. It's not that then you come in and say, wait a minute, they're wrong to say that order was affected by something Judge Waits did because there was no effect.
Correct, Your Honor.
Okay.
I see. Okay, thank you.
Okay. Thank you.
So with respect to the clerk, Mr. Blackwood, petitioner contends that Mr. Blackwood is more like a magistrate judge rather than a law clerk because he presided over ex parte meetings with prosecutors. But Judge Waits explained during voir dire that Mr. Blackwood was acting under Judge Waits's direction and supervision and was performing only administrative tasks during this ex parte meeting with the prosecutors. So for example, Judge Waits explained that he had instructed Mr. Blackwood to meet with the prosecutors and to ask them whether they had obtained Judge Waits's guidance on proposed substitutions and summaries for classified information, whether they had taken his guidance into account and when they would be providing to Judge Waits for his review and decision those revised proposed summaries and substitutions. And then he instructed Mr. Blackwood to simply relay that information back to Judge Waits. And so Judge Waits explained that there was nothing inappropriate about this process and that he would have done it himself except for the fact that he was stationed in Italy, but that it was appropriate for Mr. Blackwood to do as a law clerk because he was performing simply administrative tasks. He was not making any judicial decisions. And in fact, as Judge Libretto explained during his voir dire, Mr. Blackwood was prohibited from making any judicial decisions in petitioner's military commission case. And as each military judge who has presided over petitioner's military commission case has explained, either in voir dire or testimony or a declaration before the military commission, although they relied on their law clerks, including Mr. Blackwood, for assistance, in each instance, it was the military judge rather than the law clerks who were making the judicial decisions in petitioner's military commission case. And so because Mr. Blackwood was simply a law clerk, the normal recusal rule that applies to law clerks applies here, and that is that law clerks must be screened from cases when they accept a position with the party that appears before the court, not when they apply. And here, Mr. Blackwood accepted only one position, and that was a position with the U.S. Attorney's Office from the Western District of Missouri.
Ms. Tarrant, if we were to reject the analogy of Mr. Blackwood to a term law clerk, what would the standard then be for disqualification of Mr. Blackwood as a government attorney working on this case?
The only two standards we're aware of is a judge and a law clerk. And so we think, though, that there's no sound reason to depart from the normal rule here, where Mr. Blackwood was not making any judicial decisions, but was only assisting the judges. Mm-hmm. The petitioner pointed out that one of the attorneys from the U.S. Attorney's Office from the Western District of Missouri agreed to serve as a taint attorney in Nashiri's military prosecution if certain mental health issues arose at sentencing there. But that attorney, Mr. Jeff Valenti, explained in a sworn declaration that he has no involvement in the prosecution of petitioner's military commission case. And so because the employer and the party are not one and the same, no disqualifying conflict of interest arises as a result of his decision to accept that offer of employment. Unless there are any further questions, Your Honor, we respectfully request that this court deny the mandamus petition.
Thank you, Ms. Tarrant. Ms. Skelton, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. I'd like to
Ms. Skelton, could you, sorry to interrupt you, maybe maybe the Chief Judge won't count this in your 2 minutes. Could you just tell us why what the commission has offered as described by Ms. Tarrant doesn't give you everything you want?
Your Honor, what Ms. Tarrant described is not what either the commission or the CMCR has offered.
But this is what, yeah, go ahead.
At page 94 of the joint appendix, this is in the CMCR's decision. The CMCR said that that Mr. al-Tamir's argument about the continuing impact, invisible impact, is speculative, and that the only one example related to the female guards, that's the only one that the CMCR ordered any further review of at all. So
well, suppose we understand Ms. Tarrant is telling us what this means today, and suppose our opinion reflects that, what she said. That is that petitioner gets de novo reconsideration of any post-Waits order that he identifies as possibly being affected by the Waits order. Why isn't that enough?
It's not enough because it fails to account for a couple of things. It turns the question of taint into basically a true-false question of was this prior ruling acceptable?
No. First of all, this would only apply to a prior ruling that's reversed, right? So let's stick with my hypothetical about a discovery order. The new judge takes a look at a Waits discovery order. It says it was affected by taint, and I'm going to grant that discovery. He gets that discovery. And you say, okay, that means that the following post-Waits orders also need de novo review. And as I understand Ms. Tarrant's description of this remedy, that you get that.
So first of all, the initial reconsideration becomes the true-false question instead of an essay question. But then even assuming the one order that Judge Rubin ordered the forced cell extraction in January of 2017, that led to 5 spinal surgeries, which led to a host of questions about Mr. al-Tamir's competence and ability to participate, both mentally and physically. So that one ruling candidly voids the rest of everything that happened and every physical hearing.
Isn't that ruling getting reconsidered?
In
other words, if the new judge decides that ruling was wrong, isn't that part of the de novo reconsideration?
So it only gets reconsidered if Judge Waits's ruling gets overturned. But even if Judge Waits's ruling doesn't get overturned, then his ruling still had an impact on later rulings. So this is really an attempt to parse things so finely that it eliminates the ability of any court to sort of rehabilitate the public perception of justice. The prophylactic remedy that this court considered in al-Nashiri, it stands even stronger here. We see that al-Nashiri was not a case of one bad actor. We have seen the CMCR and the Military Commission eager to read it down to a nub. And that's and trying to parse finally how exactly to implement the most limited possible remedy shows the impossible task of trying to scrub taint from a proceeding. When the taint arose at the beginning of the proceedings, simply the proceedings must be scrubbed themselves.
I probably should have asked Ms. Tarrant this question, but has the Military Commission, have they solved this? Have they made it clear to these judges that they can't be looking for jobs while they're sitting on these cases?
The record that we have right now, Your Honor, is that they have affirmatively not fixed this problem. Matthew Blackwood testified about this. Judge Libretto commented on this in voir dire, that there has been no change in any ethical guidance that the trial judiciary has given. And in fact, Matthew Blackwood testified that he was aware of the issues percolating in al-Nashiri while he was applying for jobs with the National Security Division and other components of the Department of Justice, and it did not impact his behavior.
Okay. Unless my colleagues have any further questions, we'll bring this one to a close. Thank you, Ms. Skelton. Thank you, Ms. Taryn. We'll take this case under submission.
Case number 20-5088, Center for Biological Diversity, Appellant versus David Longley Bernhardt, U.S. Secretary of the Interior, et al. Mr. Shannon for the appellant, Mr. Helainen for the appellees.
Morning, counsel. Mr. Shannon, please proceed when you're ready.
Thank you, Your Honor. Good morning, and may it please the court. The primary issue on appeal at this early stage of the proceedings is whether the center has standing to challenge the defendant's failure to publish the guidelines implementing the Species Status Assessment Program in the Federal Register as required by Section 4H of the Endangered Species Act. And the center clearly does here because the defendant's failure has denied the center access to information that Section 4H requires the service to disclose, and there is no reason to doubt the center's well-pled allegations that this information would help the center carry out its mission to protect endangered species and their habitats, and its ability to inform both its members and the public. Now, this court has found, quote, the law is settled that a denial of information qualifies as an injury in fact, where a statute on the claimant's reading requires that the information be publicly disclosed, and there is no reason to doubt their claim that the information would help them. Now, the court applied this test in Friends of the Animals v. Jewell, 824 F. 3rd 1033, which found that Section 10C of the Endangered Species Act also establishes a statutory right to information.
Mr. Shannon, could we take a step back? I understand the center maintains that this is an informational harm, but the failure to provide notice and comment is generally thought of as a procedural harm. And so if we were to assume that it was a procedural harm, how does your claim pass the test in Summers, the Supreme Court's decision in Summers?
So,
concrete interest.
Assuming there was a procedural harm, the requirement on us would then be to show some kind of substantive harm that is attached to that procedural harm.
Right.
And I think what the defendants are doing here is reading Spokeo very narrowly, and not looking at the fact that Spokeo cited informational injury cases as a substantive harm that is attached to what can be considered a procedural violation, the failure to publish something in the Federal Register or provide notice and comment on it. However, if you look to Summers specifically, that case did not involve informational standing or even organizational standing. It solely involved organizations trying to demonstrate, did not involve organizational standing or informational injury standing. It solely involved association.
Well, that's what I'm saying. Say, just assuming that I reject the premise that this involves a proper informational claim. If it is simply a procedural harm, can you satisfy the test of Summers?
I believe so, Your Honor. I mean, for two reasons. One, there are substantive harms that the center has accrued because of the service's failure to publish the guidelines implementing the Species Status Assessment Program in the Federal Register. For instance, the center routinely submits, and this is detailed in our complaints at paragraphs 9 through 12 at JA 9 through 11, petitions for the listing of species as either endangered and threatened. And now those petitions are judged based on the criteria that is established in the SSA framework. That's the criteria on which the service gathers the best available science, and those petitions has to be decided solely on the best available science. So there's a substantive harm there. There's also a substantive harm.
I'm sorry, I don't understand. The substantive harm is that it was published in the website instead of in the Federal Register?
Yes, Your Honor. And to that point, the publication of just the SSA framework on the website is a far cry from publication in the Federal Register. I mean, as we detail in our reply brief, the Federal Register Act was established exactly to prevent this kind of confusion surrounding the publication of agency guidelines, agency rules, and the like. It was supposed to be one place where individuals could look to understand the guidelines or the regulations, whatever they may be, by which an agency conducts its practices.
How is that a harm, though, that is not shared in common with all other groups or individuals that might be interested in this information? How is that harm particularized to the center?
So it's particularized to the center because not only does the center currently have listing petitions pending in front of the court, but the center, and it's impossible to know this for sure, may submit more listing petitions than any other organization. So the fact that other organizations may also be harmed by the failure to publish the SSA program's implementing guidelines in the Federal Register doesn't deprive the center also of standing. The Supreme Court looked at this in FEC v. Akins and said, yes, this harm may be generalized in a certain sense, but because this plaintiff is requesting this information and has been denied access to this information, this plaintiff themselves is also harmed.
Well, the FEC Act, though, is very unusual in that it allows a person to challenge a non-enforcement decision of the FEC.
That is true, but on the flip side, as this court has found in the Endangered Species Act in Section 10C, and we believe they should find in Section 4H, there's also a requirement to publish these things in the Federal Register, and Congress also provided in the citizen suit provision an explicit right to enforce the non-discretionary duties of Section 4, of which Section 4H would be one of them. And we've alleged that they've failed to carry out that discrete non-discretionary duty.
I don't know that I, go ahead.
No, you go ahead.
Please.
All right, I was going to ask him about, Mr. Shannon about about your reliance on Friends of Animals.
Which one, Your Honor?
That was a 10C case,
okay.
Which is different from 4H because 10C says that that information received by the Secretary as a part of any application shall be made available. Information received by the Secretary as a part of any application shall be made available to the public as a matter of public record at every stage of the proceeding. There's nothing like that in 4H. So, I mean, to me, that shows the problem you've got because under 4H, the only thing your allegation is that the agency didn't go through notice and comment rulemaking, but you have the document, you have the framework.
We have the framework.
There wasn't anything in the. I didn't see anything in your brief that suggested that had the agency gone through notice and rulemaking, there would have been other documents you would have been entitled to. Do you see my point?
Respectfully, Your Honor, to your last point,
yeah.
We do plead in our brief that there are other guidelines that may be out there implementing the species status assessment program based on the service's prior practice of not publishing the guidelines that we allege would be subject to Section 4H's requirements.
But this is about the framework, right?
The framework is just one example of the guidelines implementing the species status assessment program. There are two other documents that we allege are guidelines that we detail in our complaint, both the state representation on species status assessment team memos. And
but you have those, right? Those are available. You have them, right?
We do now have them.
They're not secret. They're not secret, are they?
To be fair, the reason we have them is because we read about the existence of the state representation team's memo in an industry newspaper and had to contact the actual reporter who published the story to receive a copy of it. We then sent in a notice of intent to sue for the service's failure over Section 4H to publish that, and also raised other substantive concerns about the memo itself. And then they subsequently provide us not only with a copy of the memo, but issued the clarifying memoranda, stepping back some of the statements that they made in the original species state representation on species status assessment teams memo. So essentially what we're stuck with right now is a game of whack-a-mole, where we find out about these guidelines through one way or another, either a newspaper story about it, or potentially a FOIA request, or it comes up in some other context. And then the service says, well, now you have that document. And so you either are no longer injured or you lack redressability, essentially putting us in a catch-22, where we either can't plead with specificity what specific document we think we should be published, or can't get redress because they've now made that document available in some way other than what's required by the statute. But to hold as much would render Section 4H essentially a nullity. And I'm sorry, Your Honor, there was a first part to your question, but if you could refresh my memory.
No, it was about, my question was about Friends of Animals and the difference between the two statutes. Yeah, the statute at issue in Friends of Animal actually required the disclosure of information. The statute at issue here does not. It just requires notice and comment rulemaking.
Yeah, thank you, Your Honor. So it is true that Section 10C is distinguishable from Section 4H because it uses the word information. But that's not to say that Section 4...
No, that's not what makes it distinguishable. It's not just that it uses the word. It says that information received by the Secretary as a part of any application shall be available to the public.
Certainly, Your Honor. But
I mean, let me give you an example. I think you would have had a very strong case if you had argued, this is just, if you'd said, look, what we're missing here, we would learn a lot. If they went through notice and comment, agencies have to respond to comments that they get in the notice and comment rulemaking process. And the agency's responses to comments would be extremely helpful for us to understand the agency's position and its strategy. And then it seems to me you would have a good case that there's something more here. In other words, our case law says notice and comment rulemaking, the failure to do that by itself does not confer standing unless there's something more. And the something more would be, we need the agency's responses to understand the agency's enforcement strategies. But you didn't make that argument. You didn't make that argument.
I agree completely, Your Honor. We actually set forth those arguments both in our complaint and in our briefing.
You do? Where in the complaint? Would you just show me where? I mean, if you did, fine. I didn't see it.
So in the complaint at paragraph 50, and then in our first claim for relief, we note that the service's failure to provide notice on the guidelines leaves basic questions about the program unanswered.
Well, that's not what I said. I mean, I read that. I didn't know what you meant when you said that. I didn't understand that. I didn't understand what you meant by that was that we don't have the agency's responses to comments.
At the very least, in our prayer for relief, Your Honor, we asked for relief, an order from the district court requiring them to comply with the requirements of Section 4H, which would not only be publication, but an opportunity for notice and comment. And in response to our briefing stating that notice and comment could provide or alleviate some of the ambiguities and opacities surrounding the SSA program right now, the service responded that they would only need to respond to substantive comments and then assumed that none of our comments would be actually substantive. But you're correct in that if the service was actually required to publish the framework at the very least and potentially other guidelines, we don't know if there are other guidelines that might be subject to Section 4H at this early stage of the case in the Federal Register and accept notice and comment, that could very well provide us with relief. And I see that I'm moving into my rebuttal time. I'm happy to answer other questions. Otherwise, I will reserve my time for rebuttal.
Okay, thank you, Mr. Shannon. Mr. Halainen.
Good morning, Your Honors. Daniel Halainen for the Federal Appellees. So I think what the center is arguing in this case is that they're harmed by the service's compilation of scientific data in pre-decisional documents. But they're not actually challenging any final decision that relies on that information. For example, an action on a petition. They're just claiming that their desire to know more about species status assessments is a cognizable harm, but they don't have a legally protected interest in that. So it's not a sufficient basis to establish standing. There is some question in the appeal about what the appropriate way to view the standing question is here, whether it's an informational rights case, a procedural rights case, or if there's a role for organizational standing. But I think the bottom line is that under sort of any theory of standing, the center doesn't have a legally protected right to sort of insert itself into how the service is compiling scientific data. And for that reason, it doesn't have a legally cognizable injury and no standing either. And that's why we'd ask the court.
What's your response to Mr. Shannon's argument that that what's going on here is that they get wind of these documents that they believe should have gone through notice and comment rulemaking. They ask the agency about it, they get the copy, and then they're, they have it, but they haven't solved their underlying problem, which is their view that under the law, these documents should be going through notice and comment rulemaking.
So I think
he called it a game of whack-a-mole.
So I think I have two responses to that.
Yeah.
The first is that, of course, if the service uses a species status assessment in reaching a decision, for example, on a Section 4 petition, the service references that as part of the record. So the species status assessment is part of the decision there and can be challenged at that time. So if they want to bring up issues related to how the service is, compiling that species status assessment, there is an opportunity to bring that and seek judicial review. It's just not at this sort of early nebulous stage where they don't have any harm. The second is that it's of course the burden on the plaintiff to identify a sort of discrete action that they're seeking to challenge or compel. And I think an allegation that there might be documents out there doesn't yield any kind of concrete particularized harm to the center that would be enough to establish a case or controversy. I think, it is their burden to explain to the court what it is that they're actually challenging.
Mr. Halanen, it seems the government in its brief says that the primary documents that are guidelines, that might be guidelines under 4H, are available online. But are there other documents, I guess non-primary documents, that the service hasn't published even online, much less put through notice and comment rulemaking?
So I would say as an initial matter that at this stage of the litigation, we're accepting their contention that these documents are guidelines. We wouldn't concede that the framework and so on are necessarily guidelines under Section 4H. But I think what we meant by that in our brief is just that the documents that that are the basis of their claim in this case are already available to them.
But that's because they're not aware of all the documents that might be informing the agency's decision, because you haven't published them or subjected them to notice and comment rulemaking.
So I think, there is obviously always going to be an informational imbalance where the government knows all of what it's doing and the plaintiffs are seeking to, obtain judicial review as appropriate where they understand that there has been some violation of law. But again, I would say that, if they think there's a problem with species status assessments and that they're developed in reliance on documents that they think have illegally not gone through notice and comment under Section 4H, then they can challenge a decision by the service that relies on a species status assessment and causes them some harm in some way. And I think that would be the appropriate way of bringing that to the court's attention rather than just sort of alleging generally that there's a sort of programmatic failure to disclose documents. Because I think under cases like Norton against Southern Utah Wilderness Alliance, the courts have been very clear that that's just not the kind of cognizable claim that a plaintiff can bring in an administrative challenge.
So if they brought this lawsuit in their other suit, not before us here about the Rio Grande cutthroat trout, you think it might be cognizable in that context where there's a specific species determination?
I think it would obviously depend on kind of what they're claiming. But I think that would be a more appropriate way to raise the issue, because you know, the species status assessment is at that point, you know, influencing in their view a decision that they object to and that has, you know, harmed their interests. So I think, you know, they didn't raise, as I understand it, species status assessment issues in the Colorado case, but if they had brought it there, that would be the place to do it.
So, but when they do that, what they're challenging is the decision, and it's just that the species status assessment plays a role in the decision. So they're indirectly getting at the species status assessment by bringing a challenge to the final decision that's at least in part predicated on the assessment. That's the way you perceive it happening.
I think so. I mean, in the alternative, if there were actually an agency action that they wanted to challenge, they could bring that claim and say a document is legally defective for failure to go through notice and comment. Like they could challenge the 2016 framework that way, but they'd have to demonstrate an Article 3 injury that flows from that. And I just don't think they've done that in this lawsuit.
Mm-hmm. What if there were a decision, so where there is a decision that's predicated on the assessment, then you can bring a challenge to the decision. But is it possible that if there's a flaw, if they perceive a flaw in the assessment, but it doesn't, but the flaw means that the service decides not to engage in a decision, then there's no way to challenge the flaw in the assessment that led to the non-decision?
So I think if there isn't an agency action that relies on the species status assessment, then if they want to challenge a failure to undergo Section 4H, they would just challenge the document that they think should have gone through notice and comment. Again, I'm not sure if they'd be able to establish standing to do that, but that's just not the issue in this case.
Mr. Leinen, are there any documents that the service has put through notice and comment making under 4H?
Yes,
Congress seems to express a pretty firm policy that the criteria the service uses should go through this process.
Yes, so the service has undertaken Section 4H notice and comment procedures for guidelines. There were 2 in 2016, one involving priority status reviews, which is sort of one of the enumerated types of guidelines in Section 4H. That is at 81 Federal Register 49248. And there was also a policy on critical habitat that went through Section 4H notice and comment procedures in, I think that was also 2016. That's at 81 Federal Register 7226. So those are just 2 examples. But I think, you know, in appropriate circumstances where the service is seeking to adopt a document that fits within the definition of a guideline, it will go through Section 4H notice and comment. So I guess one point I would just like to emphasize is this question about whether this case is properly viewed as a procedural rights case or an informational rights case. We think that ultimately doesn't matter to the outcome of the case, but we do think the court should view it as a procedural rights case because notice and comment statutes are not disclosure statutes, and the informational injury tests have been developed to accommodate the peculiarities of disclosure statutes and the particular interests that Congress is seeking to protect when it adopts a disclosure statute. Whereas a notice and comment statute like Section 4H serves a different purpose. As we know from cases like MCI, which we cited in our brief, notice and comment has the purpose of enhancing an agency's decision-making. It's not intended to create a disclosure right. The incidental dissemination of information pursuant to a procedure like notice and comment is not the same thing as a right to disclosure of information as we understand that issue in the informational standing context. And I think on this point, the Wilderness Society against Ray case that we've cited in our briefs from Judge McCune in the Ninth Circuit really has a thoughtful explanation of why it's important to police this boundary, because I think the consequence of applying informational standing tests to a notice and comment type procedure like the one at issue here is that it kind of blurs the lines on what constitutes a concrete injury in a way that is not contemplated by Summers against Earth Island Institute and the cases that follow that. I'm thinking of, in particular, the International Brotherhood of Teamsters case from this court, which basically says, in a notice and comment situation, the allegation that an agency is not complying with the procedural requirement, that's just a sheer deprivation of a procedural right in vacuo, which is not enough. And as was being discussed earlier, I don't think that the center here has alleged any concrete harm that flows from the alleged procedural violation of Section 4H here. I don't think, pointing to disclosure online or through a FOIA request as opposed to Federal Register publication can really be conceived of as creating a concrete particularized injury to the center in particular, regardless of petitions pending, whatnot. The location of publication really is just a procedural requirement, and nothing really differentiates the consequences for any particular plaintiff with respect to where it's published. And I think that's the key issue in differentiating procedural rights cases from informational rights cases, is that procedural rights cases are very concerned with generalized grievances being brought to court as Article 3 cases and controversies, and informational rights cases recognize that in some circumstances, Congress has identified a harm that might be generalized among the public, but is nonetheless the type of thing that can serve as a concrete injury in support of standing. And that's just not the right way to think about notice and comment. So we would urge the court to conclude that this is a procedural rights case and that the center has failed to establish procedural standing. If the court reaches informational standing, I think their allegations of informational standing fail for essentially the same reason that this is a procedural rights case. There's no entitlement to information or disclosure in Section 4H, unlike Section 10C in the ESA as addressed in the Friends of Animals case, which did have a discrete disclosure provision that required the release of information. So we would urge the court to affirm on that basis. Unless the court has any other questions.
Thank you, Mr. Halainen.
Thank you very much.
Mr. Shannon, you have your rebuttal time.
Thank you, Your Honor. Briefly, I just want to address Judge Tatel's question before regarding notice and comment. You can look to paragraphs 1 and 3 of the complaint. That's on JA7. And I want to address a couple of points that opposing counsel made. One, he alleges that we're asserting to insert ourselves into this process by which the best available science is compiled in individual species status assessments. That's simply not true, and it's not an issue in this case. What we are asking the service to do and asking this court to order them to do is to publish the framework itself in the Federal Register as required by Section 4H, as we allege. And that's what distinguishes this case from individual species-specific decisions in which SSAs are made. Those documents contain the best available science for that decision, but we're concerned about the criteria by which those documents are made. It's like getting rulings from this court and we were to only receive the holding, but not know the standard of review, the rules of evidence, or the pleading standards. We need to know that kind of information beforehand. And that's exactly what Congress sought to do with Section 4H. Section 4H could have ordered the service simply to establish these guidelines and could have not imposed a specific disclosure requirement on them, but it asked them specifically to publish them in the Federal Register and take notice and comment on them. If I can quickly conclude. And Congress was also clear in the Endangered Species Act that obligation is separate and apart from generalized notice and comment obligations. If you look to Section 16 USC 1533B5, there's a catch-all provision that basically says, to the extent that the ESA doesn't have a specific disclosure obligation, then the APA's generalized notice and comment provisions apply. But Sections B and Sections H, and as the court found in Friends of Animals, Section 10C do impose substantive disclosure provisions, which can be the basis for informational injury. Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Tuesday, January 12th at 2 p.m.